Hi, welcome everyone to this last event in this academic year's Talking Animals Law and Philosophy series. I'm Raphael Fazel, the Executive Director of the Cambridge Centre for Animal Rights Law. Probably a few of you are attending this talk series for the first time, so I'm just going to say a few words about how these events work. We will be able to list a presentation by our speaker that will last for about 30 to 45 minutes, and we'll then have another maybe 40 minutes or so for Q&A and discussion. The event will end at around 6:30 p.m. Cambridge time. As always, you're very welcome to participate in the discussion. I'm sure our presenter would appreciate your comments or thoughts in the Q&A part of this event. And in case you would like to come in with a question or comment, could I please ask you to use the raise hand function, which you will find under the reactions button on the bottom of your Zoom app. And if you cannot locate that raise hand function, then you can also just use the chat function instead, if that's easier for you. I will then go through the different raised hands and the chat and allow you to ask your question directly to the speaker if you'd like to. Until that point, I will be muting all the microphones. Just to let you know also that we are recording the presentation part of this event, so you can always watch it later on our website if you want to. Okay, with this out of the way, let me now introduce our speaker. We have the pleasure of ending this year's Talking Animals series with a presentation by Ankita Shanker, who is visiting the Cambridge Centre for Animal Rights Law from April to September this year, and she's on a scholarship from the Swiss National Science Foundation. Ankita is normally a PhD in law candidate at the University of Basel. She earned a BCL from Oxford and was called to the Bar of England and Wales. After legal practice at international criminal tribunals, she undertook roles as a moot court training expert and has developed the first international human and animal rights law moot court competition. During her stay here at the Cambridge Centre, her aim is to identify the content, strength, and limits of fundamental animal rights and personhood, relying on the foundational principles of fundamental rights law and the legal theories of personhood and rights. Ankita, thanks so much for being with us today. The floor is yours.
Thank you so much for the introduction, and it's my pleasure to be here today, so thank you for having me. My presentation today is on the topic rights holding persons and the rights and personhood they hold. I am essentially presenting what forms chapter 2 of my PhD thesis, and within that, the specific aspect of the content, limits and strength of fundamental rights. But before proceeding with the main focus of my presentation, I would like to give a brief introduction that lays the background and provides a little bit of context for the discussion to follow. Under international and most domestic legal systems, humans are entitled to fundamental legal rights and legal personhood, and these are formally recognized and legally protected, but non-human animals have neither. By way of definitions, for the definition of legal personhood, I refer to Visa A.J. Kurki, who explains it as a complex property consisting of active and passive incidents. And for the meaning of fundamental rights, I refer to Raphael and Fazel, who describes it as a cluster of rights capable of generating new positions. The protection of the fundamental rights and personhood of humans was the result of a gradual process of increasing recognition and protection, but thus far, this has not happened for animals. I posit that animals hold personhood and fundamental rights under the foundational principles properly understood, on which positive international as well as most domestic fundamental rights law is based, but that this position is not currently reflected in the law's provisions or practice. The result is that there is a disconnect between the provisions and the foundational principles of law. And here are some more definitions. For positive law, I mean laws that are not enacted or adopted in legal systems, and this encompasses both the letter and the spirit of law. The provisions of law are enshrined in the letter of the law, and the foundational principles are reflected by the spirit of the law. And by foundational principles, I mean underlying principles on which laws are founded and which they purportedly seek to uphold. The framework I adopt is that of global animal law, on which Ann Peters has provided a lot of research and has written extensively, and this encompasses international and domestic laws. According to the website of the Max Planck Institute for Comparative Public Law and International Law, this has a transboundary dimension in order to find globalized solution to a globalized problem. And the main fundamental principle I have identified is that of treating like alike, which has widespread application and acceptance across jurisdictions. Animals are currently treated as property and have that legal status under legal provisions of most jurisdictions, which seems at odds with the fact of their sentience. The refusal to acknowledge animal personhood and disregard for their dignity, at least indirectly, results in a disregard for their fundamental rights. Though there is some pro-fundamental rights and personhood jurisprudence across a few jurisdictions, it is limited in number and scope, with the result being that there is no general application of the ratio decidendi of these cases beyond the instant case in which the decision was rendered, and/or there is no general applicability in legal practice. Moreover, some of these cases only refer to animal rights in obiter, with the ratio being focused on animal welfare. Ultimately, this means that there is no protection for animal rights anywhere in the world. And although animal welfare laws are widespread, they are only a stepping stone to fundamental rights, and of itself, welfare is inadequate. The law thus appears to have paused at the species divide that separates humans from animals, arbitrarily delineating fundamental rights holding persons into two groups and protecting one at the expense of the other. In order to contrast the provisions of fundamental rights law with its foundational principles, with a view to identifying and correcting internal inconsistencies between them, three preliminary issues arise. The first is identifying the class of fundamental rights holding persons under the foundational principles of law. The second is determining the content, strength, and limits of the fundamental rights of beneficiaries. And the third is determining the content of the personhood of beneficiaries. For my presentation today, I will focus on the second of these issues. In chapter 1, I addressed the first of these issues by looking to positive fundamental rights law's foundational principles, and I sought to identify the class of fundamental rights holding persons who, for internal consistency between these principles and these foundational principles and these provisions, should be encompassed by legal provisions. I identified the class of those who are legal persons and those who hold fundamental rights as encompassing all sentient beings, including sentient animals. And now in chapter 2, I will address the next two issues, which is determining the content, strength, and limits of personhood and fundamental rights of fundamental rights holding animals. So essentially for this presentation, I will focus on the content, strength, and limits of fundamental rights, and I will explore which fundamental rights animals hold, then how strong these fundamental rights are, and finally, where the limits of these fundamental rights lie. My research thus far found that fundamental rights holding person include all those who have inherent interest to protect and the capacity to experience, enjoy, or exercise fundamental rights. In other words, sentience, with the latter generating the former. As corollaries to this, the content of fundamental rights is determined by the interests of fundamental rights holders, the strength of fundamental rights by the strength of these interests, and the limits of fundamental rights by applying the foundational principles of fundamental rights law with reference to the holder's interests. For example, all sentient fundamental rights holders have an inherent interest in preserving their life and thus the fundamental right to life. But this interest and the corresponding fundamental right may be stronger for those holders who are additionally self-aware. The content and strength of fundamental rights are thus not necessarily the same for all fundamental rights holding persons. In this endeavor, I employ a species-based but not inherently speciesist approach because it relies on species qua species specific characteristics rather than species qua species. To quote Raphael and Fazl, in law, we should extend fundamental rights and cognate concepts such as legal personhood to other deserving animals on the basis of species membership rather than individual capacities. For Martha C. Nussbaum, species membership matters because it determines the community in which the individual in question lives, and therefore in which the individual either flourishes or does not flourish to, as this was a quote from her. Oh, this is a quote from her. Possibilities of flourishing in the community are defined around species norms. The species norm, duly evaluated, tells us what the appropriate benchmark is for judging whether a given creature has decent opportunities to flourish. According to Fazl's species membership approach and Nussbaum's capabilities approach, I propose using species-specific, adapting these approaches, I propose using species-specific capacities and or interest to determine the general content, strength.
Ankita, sorry to interrupt you there. It seems that I and some other people, with your slides, there was a problem. Which slide are you currently on? It seemed to be frozen. It says guiding principles now. Is that correct?
No, that is the next one. So I'm still on the...
You're still on that one. Okay, I think it looks fine again. There seemed to be some issue before, but it looks like you're good again. So sorry for interrupting you there.
Sure, thanks. Yes, so these fundamental rights can be further tailored to meet the interests and reflect the capacities of specific species members. While in this endeavor, I formulate general guiding principles for determinations and categorizations, and I do propose categorizations, I do not attempt to classify species into these, as this would be a matter for relevant experts to determine and falls outside the scope of my research. In terms of guiding principles, but first, a problem that is identified by Wendy A. Adams must be addressed. Specifically, she identifies that given that humans cannot communicate with animals, it is difficult for us to identify the interests of animals. And indeed, we are limited in our understanding of animal interests, but the best option may be to attempt to discern these in consultation with relevant experts and hope that the interests identified suffice to enable animal species in question to flourish. Some degree of specificity can be discerned from the capacities of the animals in question based on their physiology, their mental capacities, as well as the environment in which they operate. Moreover, as Raphael and Fazl points out, even if animals were to have some capacities that humans cannot understand, these might not necessarily be relevant to the protection of animals' basic interests. However, it must still be acknowledged that in light of progressing scientific research, certainty on such matters is difficult to achieve. Attempts are made to create categories in which to classify animals, and the next step for translation into reality would involve grouping various species into these subclasses, though determining the species interests and subcapacity and species interests and species capacities, as well as categorizing species, are endeavors to be had some, and in this regard, some guiding principles will be proposed for the meaningful protection and the effective implementation of these attempts. So first, determinations of species interest and species capacities and the characterization of fundamental rights holding persons should be made in consultation with the relevant experts and based on reliable scientific evidence. This should also remain amenable to adaptation in light of new evidence. This would ensure that the categories and consequently interests that are, the capacities and consequently interests that are identified are done so as appropriately as possible, and thus the determinations and categorizations are made as appropriately as possible. Moreover, it would keep these up to date. Second, determinations and categorization should adhere to the precautionary principle or an adaptation thereof, where scientific evidence is inconclusive. The precautionary principle should apply to species category capacities as well, with the benefit of doubt lying in favor of the species possessing the capacity required for stronger protection. This would ensure that determinations and categorizations are as adequate as might be needed to safeguard animal interests. Third, determinations and categorizations should be made in line with the widest and strongest known interests or capacities of any species member, as opposed to those of the typical ones, and be adjusted in accordance with any new information on any individual member. This too would ensure that the determinations and categorizations are as adequate as might be needed to safeguard the interests of all members, as opposed to just the typical ones. For determining the content of fundamental rights, the first topic is the species approach and deviations from it. From Kramer's exposition of the interest theory of rights, the purpose of rights, including fundamental rights, is to protect interests. So fundamental rights are enjoyed or exercised to protect the underlying interests of fundamental rights holders. To determine the content of fundamental rights, I will attempt to identify the types of fundamental rights to which various species are entitled, as well as to create subclasses of fundamental rights holders based on capacities, each characterized by a different set of fundamental rights commensurate with the interests of the holders, building on the premise that the content of fundamental rights depends on species capacities and which determines species interests. Determining the content of fundamental rights, therefore, entails identifying fundamental rights needed to protect these interests, which in turn depends on species capacities of the fundamental rights holder in question. For example, great apes, elephants, and whales may have cultural, including linguistic interests, and thus corresponding fundamental rights, though such fundamental rights would be meaningless for species who have no cultural and thus no cultural interest to protect, for example, sea jellies, assuming they are in fact sentient. All sentient fundamental rights holders are entitled to equal consideration of their interests rather than to identical interests. The content of fundamental rights need not be the same to ensure equality. Ronald Dworkin distinguishes between equal treatment and treatment as an equal, explaining that the former requires, in his words, equal distribution of some opportunity or resource or burden, whereas the latter simply requires treatment, again in his words, with the same respect and concern as anyone else. Indeed, if equality were to require equal treatment rather than equal consideration and treatment tailored to the needs of the beneficiary, it would achieve very little by means of securing protection for interests, which are clearly not the same for all species or even all species members. While the starting point may be to determine species interests and species fundamental rights, situations may also arise that warrant tailoring these further to reflect the interests and fundamental rights of groups of or individual species members. Alistair Cochrane explains that this differentiation or diffuse nature of fundamental rights is not a basis for denying the universality of sentient rights, because human rights also differ qualitatively and in content, and this is not ordinarily considered, in his words, sufficient reason to deny their universality. He gives examples from international human rights law where various instruments exist that are tailored to the interests of specific classes of human beings, such as women, females, children, disabled persons, minorities, etc. The fundamental rights protected under these instruments would be largely meaningless to humans who do not share the interest of these specific groups that these instruments seek to protect. So just as human rights, fundamental rights can be tailored to groups of humans based on their underlying interests, fundamental rights can be tailored to various classes or individual fundamental rights holders, for example, on the basis of species interests. The content of fundamental rights can therefore differ from species to species, and even within species from species member to species member, depending on the underlying interests of the species or member in question. For example, not only would the content of fundamental rights differ between humans and monkeys, but would also differ between adult humans and human children. So for each species concerned, determining the content of fundamental rights would involve an investigation into the interests of the species, in turn determined by species capacities. Moreover, the content of fundamental rights can then be further tailored to reflect the interests of specific groups of or individual species member as and when needed. Through this approach, the fundamental rights recognized and protected for holders would be relevant to safeguarding their underlying interests. In determining general interest and corresponding fundamental rights, as a starting point, I refer to Henry Shue, who identifies 3 basic rights that are essential for the enjoyment of all other rights, with the latter being dependent on the former. These are the rights to physical security, to subsistence, and to liberty. As fundamental rights, these have a generative property because they are capable of generating further fundamental rights to safeguard their underlying interests, the underlying interests they protect. In a somewhat similar way, Jean-Claude Delametre proposed a triad of fundamental rights for animals, the fundamental rights to life, to health, and to pleasures. In the context of animal welfare, F.W. Rogers Bramble identified 5 freedoms, which, as expressed today, include freedom from hunger and thirst, from discomfort, from pain, injury, or disease, to express normal behavior, and from fear and distress. And Peters proposes complementing these 5 freedoms, which could be, in her words, creatively understood as legal rights, by, to again quote her, more fundamental rights such as the right to life and liberty. According to Raphael and Fazl, the right to life, the right to bodily integrity, the right to liberty, the right to food, the right to shelter, and the right to an adequate standard of living are among the fundamental rights that could plausibly be extended to many animals. And finally, Nussbaum identifies a capabilities list comprising of general categories, which can be combined with Shue's, Delametre's, Bramble's, Peters's, and Fazl's list to lay the groundwork for the following general interest and corresponding fundamental rights. Security of the person. This fundamental right would entail the right to life, health, and bodily integrity. In terms of the right to life, all sentient animals have an inherent interest in continuing their life, regardless of their conscious awareness of that fact of their life, and thus also have the fundamental right to life. For the right to health, some related fundamental rights in the context of bodily health of animals entail freedom from abuse, freedom to take rest and leisure, freedom from discomfort, stress, pain, injury, fear, and distress, freedom to live in a suitable environment with, in the words of Marta C. Nussbaum, protection of adequate space, light, and necessary stimulation, including things such as sexual expression. And in addition to bodily health, animals also have the fundamental right to mental health, which would entail freedom to participate in a wide range of activities, including access to sources of pleasurable activities and freedom to engage in them, freedom to display a wide range of positive and negative emotions, freedom from discomfort, stress, pain, injury, fear, and distress, and access to environmental stimulation. In the case of domesticated animals, the fundamental right to health also includes the right to appropriate healthcare and suitable education. In terms of bodily integrity, this would entail freedom from bodily mutations, from mutilations and modifications, freedom from induced pregnancies, from overfeeding, from being constricted or restrained, freedom from being made to exhibit non-natural positions, movements, or behaviors, and freedom from being burdened with weights or loads or being harmed or tortured in any other way. And then we move on to the fundamental right to subsistence, which entails the right to an adequate standard of living, the right to food and water to ensure freedom from hunger and thirst, access to shelter in the form of a suitable environment, and in the words of David Bilschutz, the right to not be deprived of their means of living. Thus, in the case of wild animals, this would further include the right to their natural environment, and for domesticated animals, this would also include the right to an adequate housing or shelter and access to their natural environment. And we move on to the right to liberty, which would ensure that individuals are entitled to bodily autonomy, the freedom to live natural lives without undue human influence, freedom to exhibit natural behaviors and engage in their natural social structures, as well as freedom from confinement or restriction of free movement or behavior, and freedom from enforced isolation, and freedom to attachments and bonds. In terms of the fundamental right to liberty, Alistair Cochrane proposes that it is implausible to attribute to sentient animals, to quote him, the basic right to liberty. For while it is clear that many forms of confinement and interference cause non-human animals to suffer in a variety of ways, it is less clear that the restrictions on freedom are intrinsically harmful to them. To animals, to further quote him, lack the kind of capacities necessary to frame, revise, and pursue life goals and life plans of their own choosing. Given this fact, it is difficult to see why interfering in the lives of non-human animals is intrinsically harmful in the same way as it is for most humans. Cochrane thus believes that animals lack certain capacities and thus the fundamental right to liberty. However, despite his arguments, and even if animals cannot frame, revise, or pursue life goals or life plans, I posit that they still have an interest in the forms of liberty mentioned above, and thus the fundamental right to liberty. This is especially true for wild animals, particularly in the context of their fundamental right to simply be left alone. Moreover, I submit that this fundamental right is relevant even to tamed wild animals or domesticated animals, though the specific content of this fundamental right may not be identical to, for example, the specific content of the fundamental right of liberty of a human adult of sound mind. Instead, it would more resemble the fundamental right to liberty of a human child or a mentally disabled human adult, which could coexist with being placed under the partial or complete care of a guardian, and or in a modified natural environment. Such a concession does not lead to the conclusion that such tamed or domesticated animals do not have the fundamental right to liberty, or even that their fundamental right to liberty is somehow compromised in cases where guardianship would be in their best interests. Spheres of liberty can vary depending on underlying interests, and as we cannot say that human children or mentally disabled human adults are deprived of liberty by being placed under the care of a guardian for their own benefit, we cannot say this of animals who are placed under such care and who have an inherent interest in such placement. For instance, as a result of years of domestication that has now rendered the animals unable to care for themselves without human intervention. Their liberty is simply of a different type, but is certainly not absent or compromised. Moreover, to deprive them of such care would be to potentially deprive them of various other fundamental rights, such as that to bodily integrity or subsistence. Such a form of guardianship would, however, need to prioritize the interests of the animal ward rather than those of the guardian. Lastly, the right to dignity. Here, Marta C. Nussbaum identifies concepts such as, in her words, self-respect and non-humiliation being part of a political conception that is framed so as to respect them and is committed to treating them justly, as well as respect for the territorial integrity of their habitat, whether domestic or in the wild. So these I've put under the heading of animal dignity. The former capability would mean that animals, to again quote her, are entitled to live in a world public culture that respects them and treats them as dignified beings. In the context of the later capability, Nussbaum writes, to quote her, "It is important, however, that animals have entitlements directly within the conception, even if a human guardian must go to court, as with children, to vindicate these entitlements." Again, dignity takes various forms here, depending on the capacities and interests they generate. However, once again, this is not to say that dignity is absent or compromised. Before proceeding, two distinctions must be made: that between pro tanto and absolute rights, and that between general and specific rights. In the context of the first distinction, Alistair Cochrane identifies prima facie rights from concrete rights, differentiates, with the former existing, in his words, at a general level and outside of specific circumstances, and not necessarily crystallizing into the latter. These are types of moral rights, and their legal rights counterparts are, for prima facie rights, pro tanto rights, and for concrete rights, absolute rights. What this translates into is that in practice, while the former may clash, the latter do not, as the latter have been derived through balancing competing fundamental rights against each other. No efforts are made in this section to discern absolute rights, which involves considering the relative strength and limits of fundamental rights in order to balance them against each other. This is done subsequently. In the context of the second distinction from the general fundamental rights identified above, we can seek to derive various specific fundamental rights to reflect specific species interests. Applying Raphael and Fausel's species membership approach and any individual differences among species members can be ignored in the context of determining the content of species-specific fundamental rights, which aim to furnish rights that apply to all species members generally. However, in determining specific fundamental rights of individuals on a case-by-case basis, individual differences do have a role to play in further tailoring specific species fundamental rights to meet the interests of specific species members. Having determined the rough content of general pro tanto fundamental rights, I now attempt to propose categories according to the level of awareness of various species to determine more tailored pro tanto fundamental rights that would apply to them. For the categorization of awareness, I propose a threefold structure. The first is that of non-sentient species, which are not consciously aware of themselves or their surroundings, such as most plants. They may react to environmental stimuli, but such reactions are not neurological. Moreover, such species do not experience sensations or emotions. And while it might be argued that since they are living, they have an interest in continuing to do so, if sentience is both necessary and sufficient for the possession of interest, such species would not have interest in the relevant sense. Thus, the lack of sentience would preclude the possession of interests, which would in turn preclude the existence of fundamental rights. Sentient species. I use this categorization to refer to species who are merely sentient. They're consciously aware of themselves and their surroundings and are capable of, in the words of Robert Van Gulik, sensing and responding to environmental stimuli. They are able to experience sensations and emotions, and they include species of most animals. They would thus have an interest in continuing to, for example, live, as well as avoiding negative stimuli and accessing positive stimuli. These interests would therefore generate the fundamental rights to security of the person, subsistence, liberty, as well as some limited aspects of dignity. Lastly, we have self-aware species, and I use this to refer to species who are not only sentient, but also self-aware. Self-conscious species, to again quote Robert Van Gulik, are not only aware, but also aware that they are aware, thus creating creature consciousness as a form of self-consciousness. The example here is of most humans. In addition to having an inherent interest in living, avoiding negative stimuli, and accessing positive stimuli, such species would also have an interest in, for example, having their dignity respected, knowing that their fundamental rights would be protected in the future, and furthering their life goals. This would therefore generate, in addition to the fundamental rights to security of the person, subsistence, liberty, also the fundamental right to dignity. The specific content of these general fundamental rights would further differ depending on the level of awareness. The fundamental rights of self-aware species would encompass more than those possessed by species who are merely sentient. So now we move on to the strength of fundamental rights. To determine this, I attempt to create subclasses of fundamental rights holders based on capacities, each characterized by a different level of protection for fundamental rights commensurate with the capacities of the holders, and building on the premise that the strength of species interests and in turn species capacities determine the strength of fundamental rights. Subclasses of fundamental rights holders are thus to be determined based on capacities. And though members of the same subclass may have different fundamental rights corresponding to their interests, the strength of thus level of protection will be the same across each subclass. For example, dolphins, porpoises, and octopuses may be included in the same subclass characterized by a stronger fundamental rights protection than the subclasses containing coral, sea jellies, and bivalves, assuming they're sentient at all, in line with differences in species capacities. To quote Wendy A. Adams, "The principle of equal consideration for equivalent interest requires that the suffering of animals be counted equally in circumstances where such suffering is equivalent to the suffering experienced by humans." So while taking into account the suffering of animals would not necessarily mean that the interest in avoiding suffering would be equivalent, where such interest is equivalent, equal consideration would require that the suffering of animals be counted equally. Some species would have a higher capacity to experience suffering, and their interest in avoiding suffering would thus be stronger than those who have a weaker capacity to experience it. For example, humans with a high capacity to experience both physical and mental suffering would have a stronger interest in, and thus the fundamental right to, avoiding suffering than species with lower capacities for suffering, such as sharks. The same principle would apply for other interests, such as that to life or liberty, depending on, for instance, capacities such as awareness. Explaining Peter Singer's concept of equal consideration of interests, to quote Alistair Cochrane, some human beings have a mental complexity and an emotional life that far outstrips that of rats, since human beings have a mental complexity and emotional life that far outstrips that of rats, and since human beings also have the ability to make plans for and have desires about the future, it is perfectly reasonable to state that the human interest in continued life is ordinarily much stronger than that of rats. To further quote him, in the case of such a clash, and all else being equal, the right of a human would certainly win out. But the right of the human would certainly win out. But it would win out not because it belongs to a member of a particular species that must always take priority, but because it protects an interest that is stronger and more compelling. In some situations, however, deviations from the species membership approach may be warranted to consider the interests and corresponding fundamental rights of groups of individuals. According to quote David Biltitz, who is explaining Marcia C. Nussbaum's view, if we are seeking to minimize harm and we are faced with an unavoidable conflict, we would generally be required to harm or sacrifice the creature with the lesser cognitive complexity, which often tracks the range of capabilities that a creature may have. Importantly, though, these judgments will not always track the species barrier, and they will be dependent upon the capabilities of the individuals concerned. Faced with a conflict between a terminally ill, deranged chimpanzee and a healthy cat, we may be required to save the cat in this instance. If we are forced to choose, despite chimpanzees as a whole generally having more complex and varied capabilities than those of cats. We can easily consider interests and fundamental rights at the species level, but there also arises the question of considering these at the individual level. The species membership approach can be used as a useful starting point to assess the relative strength of fundamental rights of various species, but in cases where groups of or individuals fundamental rights holders must and reasonably can be considered, a more concerted approach may be warranted in favor of group or individual interests as exceptions to the general rule. Before proceeding, I will emphasize that the following discussion applies only in the context of choosing one fundamental right over the other. For example, choosing between two individuals' lives to save, letting one die passively without actively killing him or her. And not in the context of allowing one fundamental right to be exercised at the expense of the other, which raises issues of limits of fundamental rights, which will be dealt in the next section. So choosing between fundamental rights would mean that the default starting position can and must be deviated from in considerations where relevant information about the group or individual beyond species membership is reasonably available, and there arises a situation where the relevant strength of interest and corresponding fundamental rights needs to be considered. However, it would be essential to remember that in these situations, the group or individual's capacities should still be judged in light of their species membership to an extent. For example, an assessment of the capacities of an immature member of a species should be assessed in light of their potential for development, as indicated inter alia, by the capacities of the species to which he or she belongs. Another objection arises to this approach, especially in the context of deviating from the species membership approach. As Raphael and Fazil explains, in the context of what he terms meritocracy, which, in his words, rejects the idea that all human beings have a high status simply in virtue of being born human, heredity, that they possess equal rights, equality, and that all non-humans are excluded from the scope of these rights' exclusivity. Its externalism dictates that some human individuals or groups deserve stronger or even more rights than others. Moreover, he identifies that its gradualism would necessitate deciding both the rights of humans who lack the capacity for certain fundamental rights, but also of humans who partially lack these capacities. While Fazl quotes Lawrence H. Tribe, who alludes to the possibilities of genocide and slavery that would result from such a viewpoint, I submit that this would not be the case. Genocide and slavery have historically been the result of perceived and ultimately baseless assumptions and assertions about certain groups of individuals taken to extremes to violate the fundamental rights of victimized groups. In contrast, differentiating between species or even species members in order to determine the relative strength or even content of their fundamental rights, and thereby deviating from the species membership approach in individual cases, is concomitant on the relative strength of interests, which in turn depends on the actual and not imagined capacities of the groups or individual fundamental rights holders in question. As discussed in the context of the content of fundamental rights, different groups of species members or even individuals may have different fundamental rights because certain interests would be irrelevant or less relevant to them. For example, in the context of fundamental rights of human children would differ from that of human adults, and these are in fact reflected in the recognized fundamental rights of group. And this is an example given by Alistair Cochrane. There could likewise be a difference in the relative strength of fundamental rights of individuals because, again, their interests may vary in strength depending on their capacities. For example, healthy humans who are consciously aware of their life have a stronger interest in continuing to live and thus a stronger fundamental right to life than humans in irreversible vegetative states and thus without conscious awareness of their lives, prospects, or even surroundings. Another example is that persons with congenital insensitivity to pain and hydrosis, also known as SEPA, may have the same interest and thus fundamental right in avoiding injury as persons of the same species with standard pain perception, but a weaker interest, ceteris paribus, in avoiding pain qua pain than the latter, because the fact that they cannot perceive pain would mean that their interest in avoiding pain simply for the sake of avoiding it is weak or even non-existent. Acknowledging a difference in the strength or even content of fundamental rights does not necessitate the violation of fundamental rights of any individual. Such differentiation is proposed only in situations where the situation requires choosing between competing interests and the underlying capacities of the fundamental rights holder actually warrant differentiation because the interests to which they give rise differ in content or strength in a way that ought to be, in the situation in question, reflected in the content and strength of fundamental rights. Moreover, as David Wilschitz points out, such conflicts occur and can be resolved without devaluing the fundamental rights of holders. To quote him, it is important to recognize that conflicts may arise at times between human beings, with a doctor only having enough medicine to save either a 20-year-old or a 90-year-old. While we may have good reasons, without other information, for saving the 20-year-old who still has the opportunity of to live a life ahead of her, this does not mean that we do not respect the dignity of the 90-year-old or generally devalue the lives of elderly people. In a similar way, recognizing that in cases of conflict, members of a species with lesser degrees of cognitive complexity may lose out to those with higher degrees of complexity does not mean, as a general rule, that we do not respect the dignity of the species with lesser degrees of complexity or generally devalue their lives. Right, I will stop there because I overestimated 45 minutes. I see my time is up.
Do you want to cover the limits bit, depending on if you take 5 minutes or so, just to give us a sense of what you will cover there, and then we can always, cover any other points in the discussion, but it's up to you, Ankita.
Okay, I can try to very quickly finish, or I guess as far as I can.
Sure.
Oh. In determining the strength of interest of fundamental rights, categorizations have been made above in the context of content of rights, and these can be used to determine the strength and interests of fundamental rights of these beings. The strength of interest would ultimately be on a sliding scale depending on the level of awareness, and species would be placed at some point on the spectrum, which would range from various levels of sentient to self-aware. The level of species awareness can be divided into two broad categories, and within those placed at some point on the sliding scale. So for sentient species, the fundamental rights would be generally weaker than for species who are additionally self-aware. And this category would range from species that are barely sentient, for example, bivalves include, assuming they are sentient, to species that are highly sentient but lack self-awareness, for example, cats. And then for self-aware species, this category would include species who, on one end of the spectrum, have a comparatively lower level of self-awareness, for example, dolphins, and on the other, species who are highly self-aware, for example, humans. In terms of the limits of fundamental rights, in order to ensure internal consistency in the law, these limits have to be determined in accordance with the law's foundational principles, which can be discerned from instruments and jurisprudence of fundamental rights law, especially multinational ones enshrining principles of customary international law, and at least generally reflecting the general principles of law. From an analysis of document text and travaux préparatoires, as well as jurisprudence, freedom and cognate concepts such as liberty, justice, and equality, including non-discrimination, emerge as strong contenders for the fundamental rights that these instruments and laws developed from them aim to uphold and protect. Additionally, fundamental rights are to be exercised in light of the fundamental rights of others, which is also a logical conclusion of the exercise of the fundamental rights of freedom, equality, and justice. Conflicts may arise between interest and corresponding fundamental rights, which then need to be resolved through a balancing exercise. In the words of Jessica Berg, because rights entail corresponding obligations on the parts of other rights holders to respect these rights, recognizing another entity as a natural person would necessarily limit the rights of currently recognized natural persons. In some cases, the rights at issue may even be diminished if additional entities shared the rights. As the sphere of fundamental rights of one holder grows, the sphere of fundamental rights of others diminishes. Conflicts thus arise and must be resolved in order to determine the extent to which the former can grow and the latter must be diminished. For example, with the legal protection of animal fundamental rights, the fundamental rights of humans would certainly diminish to make way for the former. Humans would no longer be legally allowed to claim fundamental rights that violate the fundamental rights of animals, and the respective limits of fundamental rights of humans and animals would need to be established. To reconcile any conflicts in the application of freedom, justice, and equality of fundamental rights in this balancing exercise, I refer to Arthur Ripstein's sovereignty principle, which identifies violations of equal freedom or domination, which is making another a means to one's ends, as the legitimate basis for criminal law. While Ripstein's principle emerged in the context of criminal justice, I posit that this has application beyond criminal justice as well. For justice to be achieved in the context of fundamental rights law, equal freedom must exist between various fundamental rights holders. So when this principle is applied to fundamental rights, the limits on the just exercise of fundamental rights can be determined by the freedom of fundamental rights holders to exercise their fundamental rights and the corresponding fundamental rights of other holders to not have these exercised at their expense. The maximum extent of the exercise of fundamental rights is subject only to non-interference with the equal freedom of other fundamental rights holders to enjoy or exercise their fundamental rights. Resolving conflicts between interests and corresponding fundamental rights would entail taking into account the limits of conflicting fundamental rights, but not their strength. For example, human and fish both have the fundamental right to life, but in case of an individual human of standard capacities who is dependent on fishing for his or her livelihood, a conflict would arise between the human's life and the lives of the fish he or she kills. While the human may have a stronger fundamental right to life, this is limited by the fish's fundamental right to life. The sovereignty principle would preclude the exercise of the former at the expense of the latter. The relative strength of fundamental rights would be relevant in the context of choosing one to save, that is, choosing between competing rights, but in the context of allowing one to exercise his or her fundamental rights at the expense of another, that is, resolving conflicts between fundamental rights, it is the limits rather than the relative strength of fundamental rights that matters. Through an application of the sovereignty principle, the fundamental right of the fish would triumph, but as will be discussed in Chapter 4, derogations may still be possible from this position, which may enable the human, in appropriate circumstances, to violate the fish's right to life in order to preserve his or her own. And with that, I am done.